A sealed envelope walks into a federal courthouse, not through the Department of Justice, not through any official chain of command, through a personal attorney acting on behalf of Pam Bondi. And inside that envelope, an audio recording tied directly to Melania Trump, logged into federal evidence less than an hour later. Within minutes, a federal judge issues a gag order. Within 2 hours, the White House responds publicly. Before the docket even fully updates, before the public knows what's been filed, the political system is already reacting. That's not normal process. That's not routine procedure. That's acceleration. And acceleration only happens when something moves faster than the system designed to contain it. Now track the sequence. 8:14 a.m., Bondi's personal attorney enters the courthouse. Not a DOJ liaison, not a government courier. 9:02 a.m., the sealed envelope is logged into the clerk's evidence system. 9:47 a.m., Judge Hernandez issues an immediate gag order on all parties connected to the filing. 3 timestamps, 93 minutes, and the entire legal posture of a federal case begins to shift. Because this isn't just a piece of evidence entering a courtroom. This is a former attorney general bypassing her own institution and placing material directly into judicial hands under a personal immunity strategy. It's controlled, it's deliberate, and it changes who's in control of the case. Then comes the response. Donald Trump's legal team doesn't deny the recording. They don't dispute its existence. They don't even challenge what's on it. At least not yet. Instead, they file an emergency motion arguing that no one should be allowed to hear it at all, invoking spousal privilege as a legal shield. Notice the shift. This is no longer about truth. It's about access to truth. And when a legal defense moves from "that didn't happen" to "you're not allowed to hear it," the strategy isn't defense anymore. It's containment. But here's where the structure fractures. Because Melania Trump is no longer aligned with that strategy. Through her own attorney, she files independently, asserting her own privilege claim, separate from her husband's legal team, establishing herself not as part of the defense, but as a third-party actor with distinct rights and interests. Now the case splits in 3 directions. Bondi is trying to secure her position as a cooperating witness, backed by immunity already in motion. Trump's team is trying to suppress the recording before it ever reaches open examination. And Melania Trump is carving out legal distance, protecting her own position regardless of where the case lands. 3 strategies, 1 piece of evidence, 0 alignment. And the clock is already running. So here's the question no one is asking out loud. Who knew about the tape before the court did? And why did the system react before it even had time to process it? Because once you ask that question, the entire case stops looking like a legal proceeding and starts looking like a controlled sequence. Let's move into prosecutorial mode, because the timeline doesn't just describe events, it constrains them. The recording wasn't discovered yesterday. It wasn't rushed into court in panic. Pam Bondi filed a formal immunity application 12 days before this submission. 12 days means preparation. It means legal review, negotiation with the special counsel, and a calculated decision about when to act. So when that envelope enters the courthouse Friday morning, it's not a reaction, it's execution. Now layer the next piece. The recording is described in court filings as an audio captured during a private dinner at Mar-a-Lago in March 2023, right inside the active indictment window tied to document handling and obstruction questions. That timing matters because it removes one entire line of defense. You can't argue it's outdated. You can't argue it's irrelevant. You can't argue it sits outside the scope of the existing case, which leaves only one path: attack the messenger or block the message. And that's exactly what Donald Trump's legal team does. At 1:58 p.m., they file an emergency motion, not disputing authenticity, not disputing context, arguing instead that the recording is protected under spousal privilege and cannot be introduced without explicit consent from Melania Trump. Read that carefully. They are not saying the tape is false. They are saying the court is not allowed to hear it. That distinction is everything. Because spousal privilege is not a blanket shield. It's a narrow doctrine. It protects private communications between spouses, but it fractures the moment those communications involve third parties or occur in group settings. And according to the filing itself, this recording may include exactly that kind of context, which means the defense isn't operating from a position of strength. It's operating from a narrowing corridor. Now stack the contradiction. On one hand, the defense argues the recording is protected and must be suppressed. On the other hand, they simultaneously challenge Pam Bondi's authority to produce it, claiming her immunity agreement is invalid, suggesting misconduct in how she retained access to the material. But those two arguments don't sit cleanly together. If the recording is illegitimate, you attack its origin. If it's legitimate but protected, you argue privilege. Doing both at once signals something else: uncertainty about which argument will survive judicial scrutiny. And when a legal strategy splits like that, it's not expansion, it's pressure. Now bring in the third actor, because this is where the structure breaks open. Melania Trump, through her own counsel, files independently at 3:44 p.m. She asserts she did not consent to the recording, did not authorize its release, and is invoking her own privilege claim, separate from her husband's defense. That move does two things at once. It complicates the privilege argument and confirms the tape exists, because you don't assert rights over something that isn't real. So now the defense is no longer unified. It's fragmented. One team trying to suppress, another trying to distance, and a cooperating witness standing in the middle with immunity already in motion. Three positions, one judge, 48 hours. And every move from this point forward isn't about proving what happened. It's about controlling what the court is allowed to hear before Monday. And this is where the case stops being about a single recording and starts becoming a structural problem the system can't easily absorb. Because once the evidence is inside the court, the question is no longer what is it? It's who controls it. And right now, that control sits with one person, Judge Hernandez. Not the White House, not Donald Trump's legal team, not even the special counsel. Everything funnels into a single decision point, Sunday, 6 p.m. That's the deadline to rule on competing motions: spousal privilege, independent privilege, admissibility. Three legal claims, all colliding at once, all trying to shape what happens next. Because Monday isn't just another hearing. Monday is a locked environment, sealed proceeding, witnesses under oath, no public visibility, no media framing, just testimony, recorded, preserved, and fed directly into any future indictment decision. And if that recording enters the room, it doesn't just sit there. It gets read into the structure of the case, which means every question asked, every answer given, every silence held under oath will orbit around it. Now think about the defense strategy again. They're not preparing to counter the content. They're trying to erase the stage before the content appears. Because once it's heard, it can't be unheard. And that's why the motion isn't just a challenge. It's to suppress entirely, to treat the recording as what they call fruit of a poisonous tree, something that should never have entered the system at all. But that argument runs into a wall. Chain of custody. Pam Bondi didn't steal this recording. She accessed it under lawful authorization during her tenure, under official review mechanisms tied to document compliance. That matters, because it flips the burden. If the access was legal, then the problem isn't how she got it. The problem is that she kept it and chose when to use it. And that's not a theft issue. That's a timing issue, which is much harder to invalidate in court. Now add pressure from outside the courtroom. Within hours of the filing, senior advisors reportedly described the situation with one word: jail. Members of Congress call for investigations into the cooperation agreement. Legal analysts, across ideological lines, Acknowledge the privilege argument faces a high bar when statements involve third parties. That convergence matters. Because when opposing legal camps start agreeing on the weakness of a core defense argument, the case stops being partisan. It becomes structural. And structurally, the defense is narrowing its options down to one outcome: delay. Delay the ruling, delay the hearing, delay the exposure. But delay only works when the system moves slowly. The system isn't moving slowly anymore, because every action now triggers a counteraction. Tape submitted to gag order issued. Gag order issued to emergency motion filed. Emergency motion filed to independent counsel enters. Independent counsel enters to privilege, conflict expands. That's not linear progression. That's escalation. And escalation compresses time. So now we're not watching a case unfold over months. We're watching a legal system forced to resolve a high-stakes evidentiary conflict in less than 48 hours, under pressure from 3 competing strategies, each one incompatible with the others. And when a system designed for deliberation is forced into acceleration, it doesn't just reveal outcomes, it reveals limits. And limits are exactly what this moment is exposing. Because strip away the personalities, strip away the headlines, strip away the legal jargon, and what you're left with is something far more uncomfortable. A former Attorney General, Pam Bondi, took material she had lawful access to, held it, negotiated immunity, and delivered it directly to a federal judge at the exact moment it would have maximum impact. That's not a leak, that's leverage. And once leverage enters the system, the question is no longer, is this legal? It's, what does this do to trust? Because every ordinary person watching this has been told the same thing their entire life. Government communications are protected. Internal materials stay internal. Power comes with responsibility, not advantage. But here, the advantage is the story. Now flip the perspective. Imagine you're not a president. You're not a cabinet official. You're just a citizen caught in a federal case. You don't get to retain classified adjacent materials. You don't get to negotiate immunity from a position of institutional knowledge. You don't get to decide when evidence enters the system, but someone did. And the system accepted it. That's the moral fracture. Because this is no longer about Donald Trump versus prosecutors. It's not about party lines. It's not even about whether the recording helps or hurts a legal case. It's about whether the rules operate the same way for everyone, or whether proximity to power rewrites how those rules function in real time. Now go back to the defense. They are trying to suppress the recording entirely, not contextualize it, not challenge its meaning. Remove it. Eliminate it from the record before it shapes testimony under oath. Because once it enters Monday's sealed hearing, it becomes something else. It becomes a reference point. Witnesses will be questioned against it, statements will be compared to it, silence will be measured around it, and from that point forward, the case doesn't revolve around allegations anymore. It revolves around consistency under oath. That's where cases harden. That's where contradictions become perjury risks. That's where narratives collapse. And that's exactly what the system is trying to avoid or force, depending on which side you're on. So here we are. Sunday, 6 p.m., Judge Hernandez rules. Admit the tape, and Monday becomes the most consequential sealed proceeding in this entire investigation. Suppress it. And the fight escalates upward. Appeals, delays, extended timelines. But the question never goes away, because the tape is already on record. It exists. It's logged. It's real. Either way, something breaks. Either the barrier around executive privilege weakens in a concrete, documented way, or the system signals that certain evidence can be buried, temporarily or otherwise, before it's ever tested under oath. And that brings us to the only question that actually matters. If the truth exists inside the system, but the system itself decides whether it can be heard, is the system still neutral? Or is it just another player in the outcome? If you followed this all the way through, you already know this isn't just about one case. It's about whether the rules still mean the same thing. when the stakes get this high. Like the video if you think evidence should be heard, not hidden. Comment below. Should the court admit the tape or suppress it? Share this with someone who still believes the system always plays it straight. And subscribe, because when that ruling drops Sunday night, we're breaking it down the moment it happens.